You've reached the voicemail for Jim Billings, Executive Director of the Maine Commission for Public Defense Services. Please leave a message at the prompt, including your name, phone number, and the matter you're calling on, and I will get back to you or have someone else from the Commission get back to you as soon as possible.
Hi, I'm not going to leave any of that information because you actually won't get back to me. But I have a question, and maybe what I'll just do is keep calling until I actually contact somebody up there and can get an answer to this question. It's a well, I think it's a reasonable question. It's the question is this: why do the attorneys that the Maine Commission on Public Defense Services appoints, why do they sabotage their clients? That's what I'd really like to know. I can understand if they were maybe just lazy or, they're just whatever, outside of their area of expertise. Any number of reasons why they might not be especially effective, I suppose. But this thing about actively sabotaging their clients, that's what I really don't understand. It's been bugging me for years, really. It only really fully formed in my brain as what's going on, what's actually taking place here, pretty recently. But here's the deal. Let me give you some specifics so we know what we're talking about here. I am accused of a couple of crimes. The charges are utterly baseless. They're absurd. I protest against the police a lot, so I get charged with crimes falsely quite a bit. And I'm poor, so I in the past, up until quite recently, have always had my attorneys appointed through the Maine Commission on Indigent Legal Services, now the Maine Commission on Public Defense Services. And they always do the same sorts of things. It's really strange. No matter how baseless the charges are, they will flatly refuse to file a motion to dismiss. Which is, if you talk to a private attorney, if you, watch a YouTube video about defending yourself in court, or it's almost common sense that, if the case is weak, you will want to introduce a motion to dismiss. It's for, if nothing else, for appellate reasons. On appeal, if you have to appeal the case, then you might well want that in the file. It's universally recommended as a good thing to do, and there's not really any downside. The downside is it's not granted, but at least you tried. But it doesn't matter whether any elements of the crime are met. They can accuse you. I stand currently accused of disorderly conduct, and I just went through it and see, here's the thing. What happened is, along with another charge, which is equally absurd, but for different reasons, I was charged with disorderly conduct. Basically for swearing, for using 4-letter words in public. But I had prior police consent or whatever, that was not going to be an issue. That was within my rights to do. And it's just nonsense. It's because I was protesting against the police, so they're charging me with disorderly conduct, is what it amounts to. And I wanted, right from the get-go, of course, to move to dismiss the charges. But I wasn't sure of the details. So I kind of posed it in a written question to my attorney, who was appointed back in December, Jeffrey Toothaker. Was appointed to me by the Maine Commission on Public Defense Services. And he wouldn't talk to me for about a month and a half. But then when he finally did, one of the very few things he said, he wrote me a letter, very brief, like 1-page letter. But one of the few bits of information he passed along was that case was dismissible. He didn't say that in so many words, but he said that that case is free speech and the other case is triable because, they're lying about the facts, basically. So if the first one is free speech and the second one is triable, that clearly implies that the first one, the free speech one, is dismissible. And obviously, it is. I myself wrote a motion to dismiss. And I went through and broke it down into elements. I really didn't, not a single one did I violate, really. They argue that I violated one. They don't even allege that I violated most of the elements of the statute. They allege that I used 4-letter words in public. It's not a crime. It's conceivably one element of the disorderly conduct statute. But obviously dismissible case. So, and that's what Toothaker, the attorney that your commission appointed to me. And by the way, they don't let you. It's really hard to represent yourself. You try to represent yourself and the judge and the DA, they don't like that stuff. And they will, do whatever they can. If they keep you in jail like they used to be able to do before the ACLU sued them recently, they just keep you in jail until you agreed to take on an attorney. So they did to me a couple of years ago. They really don't like you to proceed on your own because you might be effective, I think. I'm starting to think that's why it is. Because again, back to Jeffrey Toothaker. So, yeah, he said he leads me to believe he's going to get it dismissed, and then he won't meet with me or talk with me for another month or so, and then I put in for my first of 2 requests to have him withdraw, basically, and the judge denies that and says no, orders him to meet with me in person, and orders me to meet with him in person at the courthouse. And he shows up and he meets with me for like 5 minutes and then blows me off for the entire rest of the time. During that 5 minutes or so that he meets with me, well, for one thing, he tells me about a murder. He tells me about a murder case where he is, I say, I want to proceed pro se just with the advice of counsel. He says, that's no problem. I am representing, or I have another client who is representing himself in a murder case. And he's guilty as hell, says Jeffrey Toothaker, this guy's attorney. And I am taken aback by this, naturally. And I say, oh, really? And he says, yeah, and there was more than one. By the way, how do you want to proceed with as far as, opening and closing? And then he just changes the subject. But he just, within the first minute, literally, of me actually meeting and speaking with this guy, he is committing a serious violation of the code of ethics, the Maine code of any code of ethics. He's violating attorney-client confidentiality just right off the bat. And then he goes on to assure me that, oh yeah, he's pretty sure he can get this case dismissed. He can get it dismissed, and and then he disappears, and basically does what he needs to do to make sure that I don't get to attend my own dispositional conference and talk about any of this or the motions I've introduced. And then he won't talk to me again for another month and a half. More than that. Closing in on 8 weeks. Coming up on docket call. And I finally get in touch with the guy. And he tells me at this point, after assuring me that he can get it dismissed and saying it, strongly implying it's dismissed all along. And me asking him, can I, as defendant, just, introduce my own motion, is that something I can do? And him just ignoring that question. Then he tells me, oh no, he does a 180. He said, no, they're not going to dismiss after all. It's a factual dispute. The opposite of what he said all along. And I call him on that, and he just basically hangs up on me for all intents and purposes and won't talk to me. And then he showed up at court today. Today was the docket call. He showed up about 40 minutes late. And then he and the district attorney and the judge meet for about 10 minutes, and they come back and they say,
10 seconds of recording time left.
they're going to allow me to proceed on my own. Just what the hell is wrong with you? That's what I wonder.
To send your message, press 1. To send your message as urgent, press 2. To re-record your message, press 3. To review your message, press 4. To append to your message, press 5. To transfer to the operator, press 0. To cancel this message and exit, press star. Thanks. Your message was sent. To log into your mailbox, press pound.